Hi, everybody. In today's class, we're going to be talking about property, and specifically, we're going to be talking about the law of personal property. So, what I want to do in this video is first, I want to give you a brief introduction to the ownership of property. Property law is basically mainly concerned with that. What is ownership? What rights does it give to people who own things? And how are disputes over that resolved? Um, now, it's not really possible, and I'll give you a little bit of overview of some of the key concepts. Um, now, in a brief lecture like this, I can't really give you like a full course on personal property, but there are two. After that, there's two specific topics that I want to kind of focus on and look at some cases. The first kind of deals with this question of where does ownership come from? This is a philosophical or theoretical question, and we'll look at cases that have kind of settled in the common law system on the idea that ownership, like conceptually, why do we own things, comes from possession. And we'll look at some cases involving either abandoned property when somebody finds it, or wild animals, things that we pick up from nature. How do you gain ownership of those things? Um, and then finally, we'll look at a case that deals with the boundaries of what constitutes property, and specifically there we'll be looking at dogs. Dogs pets, not just dogs, but the case we look at happens to involve a dog. Um, they're considered a form of property by, I think, almost all legal systems in the world, but they're not. Most people, when they have a pet, they don't really necessarily think of it in the same way that they think of other forms of property. They think of it as sort of lying between property on the one hand and like a member of the family on the other. How does the legal system sort of, put the boundary between those two? And so we'll look at a case that deals with that, like which kind of tests the boundaries of what's considered property. Um, so to begin with just some like basic concepts, there's two categories of property, and most legal systems in the world do this. This is how we call it in the common law system: personal, or sometimes referred to as chattels, and real. In simple terms, personal property is property that can be moved. Things like these books on the shelf behind me. These are things that can be easily picked up and moved. Um, Real property, on the other hand, deals with ownership of land and things that are attached to land. So in today's video, we're talking about the first one, personal property. In the next one, we're going to look at real property. The physical characteristics of these two different types of property necessitate different legal rules to govern them, and so the law treats them differently. So today we're talking about the first one, real property, basically things you can hold in your hand. Actually, not just things you can hold, like cars and stuff that are too big to hold in your hand, but you get what I mean. Stuff that's not attached to land. A second kind of distinction between two concepts that's really important to understand is the difference between possession and ownership. The term possession refers to like the physical act of being in control of something. Um, Ownership, on the other hand, refers to the legal right to own, like the property right that you get from that. Perhaps a good way to illustrate that, I'll just like grab a book off my shelf here. This book is not mine. It belongs to the library, but I'm in possession of it right now. I have physical control of it, but it's not my book. So I possess it, but the actual ownership right, the legal rights to this book, belong to Nagoya University's library, law library, and not to me. So possession and ownership are two distinct things. They are related, and we'll look at some cases that deal with that. But just bear in mind that when we use the words possess and own, we're talking about different things in a legal context. So if you do own something, if you do have like a property right in it, what is that right? What rights does ownership give you? We usually say that owning something gives you like a bundle of rights. It's several things that go together. And I've kind of listed some. It's not an exhaustive list, but if you own something, you have the right to dispose of it. You can abandon it. You can throw it away. You can consume it. If it's like I have a cup of coffee, it's mine. I can not the cup, but the cup is mine, but also the content is mine. I can drink it. You can sell it, enter into a contract to give possession away, or sorry, give ownership away. You can give it away as a gift. The law of gifts is in the common law system. It's treated as part of our rules on property, not on our rules on contract. That's a little bit of a difference between the common law and civil law systems in some countries. You can paint it orange or any other color. In other words, you can alter it as you wish. And kind of key is that you also have the right to exclude other people from doing these things to it. It's yours, it's not theirs. And so this is what we say when you have a bundle of rights. You can do many things with your property, and only you can do those things, unless you co-own the property. We'll talk about that in respect to real property. But to take the discussion back, so that's sort of like, that's a very, very like simplified version of it. So we property law, we divide it into real and personal, ownership and possession, and you get this bundle of rights when you own something, when you buy something, or somebody gives you something. But where, philosophically speaking, where does ownership even come from in the first place? Why, in other words, do legal systems, and this is not limited to the common law, but sort of like human beings, why do our societies recognize rights of ownership, rights of owning things, physical objects? So there's a few different schools of thought that in answer to that question. The philosopher John Locke argued that maybe we get ownership. It represents like the fruit of our labors. We create something. If you you chop down a tree and make logs and build a house with it, you've worked, and therefore society kind of recognizes, yeah, you should own that thing that you created because it's the fruit of your labor, and we want, society and humanity wants to encourage people to do that. A second way of looking at it might be, well, we recognize ownership in things. It's kind of like from the common consent of the rest of humanity. Like our right to own something that we have rests not necessarily in the fruit of our labors, because like actually most of the things that we own, probably you own, and myself as well, we didn't make them ourselves. I mean, you work for money and you buy things, but you also get things like gifts and stuff that are completely unrelated to your own labor. But rather, the common consent of the rest of humanity. Like we recognize that ownership in things, because we kind of expect others to do the same. And I'll recognize your ownership of that, you recognize mine, and we have this kind of like system that's developed that way. A third and more like simple and practical way is that we recognize ownership from possession, from simply having control of something. And in the common law system, in actual cases, this last one, possession, has tended to be the way in which we've justified from a theoretical and like a philosophical perspective, where ownership comes from in the first place. So we can look at a couple cases that deal with that. Actually, 3 cases. One of the earliest ones, and this is the one that often gets cited for this idea that ownership comes from possession, is this case of Pearson and Post, and deals with it. It's a wild animal case, ownership of a wild animal. This is, as you can see, it's from 1805, so it's more than 200 years old. It's an American case, and the facts of this case were that Post was a hunter who was chasing he was hunting in the forest, I guess, and found a fox, like a wild animal that he wanted to catch. Had his musket or whatever they used back then, and he had some hunting dogs with him. He's like an organized like hunter, and he started chasing this fox. And I guess I'm not a hunter, but I guess it requires a lot of labor and strategy to chase one of these things. And he put a lot of effort into it. It was like a difficult animal to catch. Finally, at the end of his long quest to catch this animal, he has it kind of cornered and is about to shoot it or catch it, when suddenly, out of nowhere, Pearson, the other party in in this lawsuit, comes out of nowhere and catches the fox and takes it away from him before Post could could execute his final maneuver or whatever he was planning to do. So a lawsuit ensued. So Pearson says, "Hey, okay, this is mine. Haha, you don't have it." And Post sued, um, arguing that that animal is my property. My actions in what I've just described, which is roughly, I'm paraphrasing roughly the facts here, but my actions gave right to gave rise to a property right in that animal. Um, Now, when animals or other things are in nature, nobody owns them. There has to be some sort. So legal systems have to, in answering a question like this, they have to devise some sort of set of rules to recognize when that thing ceases to be part of nature, and starts to be like somebody's property. And so the court had to evaluate like the things that Post had done, um, in order to determine whether at some point in that series of actions of like chasing the animal and having his dogs help him and these sorts of things, it kind of like click over and where this animal stopped being a wild animal and it became like his property, or did that not happen with respect to Post? And Pearson, by actually being the one who caught the animal, did he become like the one who made that kind of conversion? And the court basically held. So basically, the question was like, is chasing an animal? I mean, this is like not how the court phrased it, but this is like a simple way of understanding it. Is the act of chasing something, like what Post was doing, sufficient to to turn to give you a property right into it, to give you a right to ownership, or is that not sufficient? And the court held that it was not sufficient. Basically, the court held that um, Pearson was the first one to take possession of the actual animal. What Post had been doing was chasing, um, and chasing something is not sufficient. We get our right to ownership of something that previously nobody owns and it's sort of like up for grabs, like a wild animal, when you take possession of it. When you take and what's possession? So to get possession, you have to exhibit an intention to possess the thing, and you have to take it under your control. Post had been indicating an intention, but had not actually gotten the animal under control. um, and so Pearson got the animal. um, and so this idea that you know that comes out of this case, and there's similar cases after it, um, is that the key to ownership, historically, if you go prehistorically, many thousands of years ago, human beings were surrounded by nothing but wild animals and wild stuff. And in theory, our ownership system comes from people picking up those things and kind of saying, I intend to own this. Look at this, everybody. This is mine. I'm holding it. And that's sort of like, obviously, we're talking much more recent in history in this case, but that's sort of like the philosophical idea of where ownership comes from. Another case that kind of deals with something similar in a different context is shipwrecks. I like this case, Eads and Brazelton. This is another American case from the 19th century, from the state of Arkansas. This case doesn't deal with like a wild animal. It deals with something that was actually like previously had an owner, but no longer did. So you'll excuse my this is my crude artwork to illustrate the facts of this case. This case takes place on a river. I think it was the Mississippi River. And there was a shipwreck, a boat that had sank in the early 19th century. It's called the America. And it had a valuable cargo inside of it, lead, which is very heavy, but could be sold. And it had sank like several decades before this case happened. And the original owner of that ship had basically abandoned it. And abandoning it is basically what somebody does when they basically renounce their ownership right to a piece of property. And when something is abandoned, um, from a legal perspective, it becomes kind of similar to what a wild animal would be. Like the first person who can get it, like who can take possession of it, gets to keep it. And so that was the case with the shipwreck. And let's see, Brazelton, he was the owner of a boat, and he found the shipwreck. So it was underwater, so for a while it was a bit unclear where it was. He located the shipwreck, and he wanted to take up the cargo, um, and sell it or whatever. But his boat wasn't big enough to do that. So what he did was you can see my little picture here. I tried to he attached a little buoy to the shipwreck, to mark that this is where the shipwreck is, and yes, I, a human being, have found this. Um, and also on some trees that were like on the shore next to the shipwreck, he put some signs there to indicate where the wreck was, and it's kind of to tell other people, not so much like here's the shipwreck, go get it, but rather to indicate that he intended to take possession and ownership of this wreck that he had found. So he put those up, but his boat wasn't sufficient to actually like take the stuff up. So he left, intending that he would later come back and pick it up. And he delayed. He didn't do it fast enough. And while he was gone, this other person, Eads, came along with a boat that was big enough to do it and picked up all the lead and took it off. It kind of just like ignored whatever markings that Brazelton left. So it's kind of similar to the previous case. You have like one person who's invested some time and effort into trying to sort of like awkwardly indicate to the rest of the world, hey, I this is mine. And then you have this interloper who kind of comes in at the last minute and takes the fruit of their labor away from them. And so there's a lawsuit, and so Brazelton sued, saying that is mine. And again, the question was, okay, well, was Brazelton's axe sufficient to turn this thing, which nobody owned, into something that he owned? And again, and in most of the cases that deal with this sort of question, it's like kind of you have to the courts have to evaluate like based on the facts. These things that they did, was it sufficient to do that? And again, possession is what he had to demonstrate. Now here, the reason Brazelton couldn't physically possess, like couldn't physically take control of the thing because of the situation he was in, right? It was like a lead on the bottom of a river is very, very difficult to just like, you can't just like, I forget how deep it was, but you couldn't just reach in and pick it up with his hand or anything. So in that type of situation, like given the nature of your discovery of the property, it's not necessarily always going to be a requirement that you physically like pick the thing up and kind of show it, like I've got it, like in the previous case. But was this act of just like marking the territory enough? And the court here held no, that his actions weren't really sufficient to constitute possession of the lead in the shipwreck. The court held that what he was doing was by putting these buoys and these markers up, he was indicating a desire to possess something. His intention, a desire, an intention to eventually possess it. But he wasn't really doing enough. The court held that in order to be sufficient for us, like the judge, to recognize you as taking possession, there was more that you could have done. You could have left the boat there to kind of warn off other people. Simply marking it isn't quite enough. And so his actions were held to be not sufficient to actually constitute taking possession of the content of that shipwreck. A final and like slightly more contemporary case deals with baseballs. This is a somewhat famous case. It's about from 2002. It's a little over 20 years old. This is Popov and Hayashi. In the picture here, this is Hayashi. He was the defendant in the case, and you see he's holding up a baseball. I won't play it here, but there's this. I put this YouTube link in the slides. You can see the actual event that gave rise to this case on that. It's about like a 3-minute clip. that baseball that he's holding, it was hit by a baseball player named Barry Bonds, who in 2001 he set the major league record for most home runs, and that ball is the ball that he hit to set the record. Um, Among like baseball fans, that's a very very valuable thing. It was estimated, I forget. The ball was worth about $500,000 because it had like a collector value. And so Hayashi and also Popov, and there's a whole bunch of people. These were fans that were at the game where Barry Bonds hit this home run. And the home run, if you know baseball, home run is a ball that is hit like outside of the play of field and into the stands where fans sit and watch the game. And the way that that works, so a baseball is in a professional game is owned by the team or the league. That's who has the property right in it. But it's already been established that when a ball at a game travels into like the stands, like where fans are, it's considered abandoned property. And the first person to get it and take possession becomes the owner. Similar to the based on the principles that we talked about in the past two cases. So if you're ever at a baseball game, like maybe here in Nagoya, you go to a Chunichi Dragons game. This is a civil law country, but the rules are somewhat similar. If a ball is hit into the stands and you take possession of it, it becomes yours. You gain an ownership right into it. Now, normally this is not like a big issue because like a baseball is not worth very much. But when it's a $500,000 baseball, lots of people want that ball. And so what happened on this case, and you can see it in the clip, the ball was hit into the stands, and there's two people there. There's like dozens of people, but Popov and Hayashi are the two main characters. Popov, he was, the ball was basically hit to him or towards him. He was the closest, and he reached out his hand. He had like a baseball glove on, and the ball kind of like came into his glove. And like the moment it was like he was about to catch it, this big crowd of people like literally jumped on him. I mean, you can see it in the clip because there was like dozens of them. They all wanted it. It's like it's kind of like a free for all, very violent. People were jumping on him, trying to like get the ball from him and stuff like that. And so he didn't actually quite catch it. It's sort of like he's I got it, and then boom, and the ball came loose. And then there's this big scuffle and the big pile of people, and everybody's, where'd the ball go? Where'd the ball go? And Hayashi emerged from that big pile of people as the person who's holding the ball. And that's actually what this picture is. And so Popov sued. And so Hayashi said, okay, this is my ball. Popov sued and said, no. That was my ball. I had it. I almost had it. And so you have this like dispute over who gets ownership of this baseball based on that specific fact situation. So Popov tried to on the slide here of this word conversion. Popov tried to sue it in conversion. That's conversion is kind of like this civil version of theft. It's when somebody has taken your property in order to turn it into their property. This is what you sue for. And so Popov wanted to sue for that. Hayashi, you took my property, and I'm entitled to it back. But in order to establish that, he would have to first establish that was his ball, that he had owned it, and to do that, like similar to the previous cases, abandoned property, you have to establish possession in order to become the owner of it. And possession means intent. You have to show an intention to own this thing. And you also have to have exclusive control. It has to be like under your control, not like under like a sort of contested control. And that was the issue. The second one was the issue because Hayashi definitely had both of these. He you can see in the picture, right? He's definitely got possession, or he's got exclusive control of that ball. He's the only one holding it, and obviously he intends to keep it. But before that happened, was this thing that Popov did, like trying to get the ball and have it like kind of like, according to him, it kind of like hit his glove and then fell down, and then like he got tackled. Was that enough to establish uh, uh, possession. Um, and the court basically held no, it wasn't. Popov didn't get possession. But and so normally that would be fatal to his claim. In other words, Hayashi was the first one to get both of those things, like to establish that he intended to possess it and to actually like have exclusive control over it. Therefore, he gets the ownership. But there was this twist in this, which was that what was the relevance of interference by the wrongdoers? So Popov was and both of these were like normal people, not bad guys. If he had been left unmolested by this crowd, he would have caught it, and it would have definitely been him who got it first. And he was actually a criminal offense had been committed against him by these other people who had jumped on him. They were committing an assault. And it seems kind of wrong, and it seemed kind of wrong to the judge too, who was hearing this case, to allow a criminal act, or actually several criminal acts, to interfere with someone, gaining possession of something which they otherwise would have, and have that affect their legal right to something. And so the judge drew this distinction that didn't exist beforehand between possession or the right to possession. And this is a quote from the case. It's where an actor undertakes significant but incomplete steps to achieve possession of a piece of abandoned personal property, and the effort is interrupted by the unlawful acts of others, the actor has a legally recognizable pre-possessory interest in the property. That pre-possessory interest constitutes a qualified right to possession, which can support a cause of action for conversion. So what the judge was basically doing there was creating, and this is, remember, like in this common law class, we've seen in previous classes that judges, when they get a novel set of facts that they can't really necessarily like fit quite into like previous precedent, they sometimes have a residual authority based on equity to create something new, and that's what they were doing. The judge does here. So I'm gonna recognize that he didn't have possession, but it sort of seems unfair to say that he doesn't get anything based on that because of the relevance of this violent act that was committed against him. So I'm going to create a new interest. It was called a pre-possessory interest that didn't exist before in law. And that pre-possessory interest gives him some quite a qualified right. So it means he has like more than nothing, but not quite the same as possession. So the judge had to sort of like unpack what that meant. And in doing so, kind of like this is some more quotes from it. He noticed that there's this kind of like conundrum that the facts sort of created. Okay, Popov has like this sort of like this thing I've just invented, a pre-possessory interest, but Hayashi has like the clear claim under like the normal rules. He was the first one to have possession. So what do I do? And the conundrum is an award of the ball to Mr. Popov would be unfair to Mr. Hayashi, and an award of the ball to Mr. Hayashi would unfairly penalize Mr. Popov. It's a difficult case. Both men have a superior claim to the ball against all the world, like everyone else, all the other people there. And each man has a claim of equal dignity to the other. So it's basically saying, you know what, this new right that I've created doesn't trump the one that Hayashi has. It's sort of, it's like a tie. So we're left with something of a dilemma. And so the solution he came up with is what we call equitable division. And this is the quote here. The court therefore declares that both the plaintiff and defendant have an equal and undivided interest in the ball. Plaintiff's cause of action for conversion is sustained only as to his equal and undivided interest. In order to effectuate this ruling, the ball must be sold and the proceeds divided equally between the parties. So the judge basically came up with a remedy that seemed fair based on these rules that he's sort of just created. That the ball would be sold and each of them would split the difference. I think following this decision, the ball was sold for like about $500,000 or so, and so each of them got that money. It's a lot better than cutting the ball in half. So this is an interesting case, not just for like what it says about like, you know, how do you acquire property, but it also about like how judges in the common law, when they're confronted with something like this, they can create new remedies and rules